As questions around the age of our elected officials permeates Capitol Hill, that fight is spilling over into the nation's court system. Last week, 96-year-old appeals court judge Pauline Newman was suspended from hearing cases for a year after a panel of her fellow judges determined she would not cooperate with an investigation into her mental competency. That panel says the longest-serving member on the court, quote, suffers from a disability preventing her from effectively discharging the duties of her office. They also claim that the Reagan-era appointee has shown significant mental deterioration and that she has been lagging behind her colleagues in issuing opinions. Judge Newman is appealing the suspension and said in a statement that the court's handling of her investigation could help undermine trust in America's courts.
So joining us now is Mark Chenoweth, the president and general counsel at the new Civil Liberties Alliance, which is a nonprofit civil rights organization formed to defend constitutional freedoms. This organization is representing Judge Newman in her appeal. Mark, welcome to Morning Rush. Thanks for joining us today. So let's start with where the appeal of Judge Newman's suspension stands right now.
Sure. So this is an administrative process in the federal circuit. The ruling that came down was from the Judicial Council, which is all of the judges on the federal circuit, but in an administrative capacity, not in their capacity as judges. And so that will be appealed now to there is a nationwide panel that looks at these disability issues for the entire federal judiciary. That's the next body that will look at it, and really the first body that will be able to take an independent look at these issues, because so far it's just been her own colleagues who have been acting as witnesses, prosecutors, and judges in her case.
So this council interviewed several people on the staff, the court staff, saying that her abilities point to significant mental deterioration, including memory loss, confusion, lack of comprehension, paranoia, anger, hostility, and severe agitation. Again, that's based on interviews with fellow court staff members. What is her defense against this? What's her case?
Well, yes and no. I mean, first of all, none of those interviews were under oath. These were not interviews that were where we had an opportunity to be in the room. These weren't depositions that you had a chance to challenge and so forth. These were one-sided conversations with court staff by the leadership of the court, the people who they report to, the people whose thumb they are under. So it's not the kind of witness process that you would like to see, where you have an independent opportunity. Second of all, let me just say, we've been working with Judge Newman from the beginning of this. The way that the court has tried to portray this, they're trying to take advantage of what we see in the media with Senator Feinstein and Senator McConnell, and maybe to some extent President Biden as well. They're trying to plant this seed that Judge Newman is not competent. Judge Newman has been issuing decisions all year long. They're fantastic decisions. We've met with her many times. She is not mentally deficient. And the fact that they're trying to assert this, and by the way, they took her off the bench before they started the investigation, which is unlawful. And that's how we got involved. We said, look, you can't be taking judges off the bench before you even start the investigation. That's a violation of her due process, and frankly, a violation of the rights of people who would be appearing in front of the federal circuit.
So at what point do you think, because you made a good point, the age of politicians has really come, I guess, into the spotlight, especially after McConnell's episodes of what looked like freezing for long periods of time while speaking. And that has really come to the forefront, especially in the last couple of months.
Dianne
Feinstein, yeah. But my question is, at what point then, where do you draw that line, I guess, where it's not, discriminating against someone, because of their age and saying, okay, because you are 90 or 85 or 80, then you are automatically inept at your job and you can't do your job. But where do you draw that line?
Yeah, Judge Newman is a super ager. She's really, I'm amazed at how in control of her faculty she is for someone who's 96. I mean, she's just, she got a PhD in chemistry in 1952 from Yale University. There weren't a lot of women getting PhDs in 1952, let alone in chemistry, let alone at Yale. So she's just a super amazing, impressive individual. And in terms of where you draw the line, the Constitution draws the line by saying that folks need to be impeached. These are lifetime appointments, as we saw with Justice Scalia dying in office, as we saw with Justice Ginsburg dying in office. if these judges want to die with their boots on, they are allowed to do that. That's part of the system. And if they get too far along, then Congress can impeach them and the Senate can remove them. But that has to be by a supermajority vote of the Senate, not by just a majority vote of their own colleagues on their own bench. Furthermore, what the statute requires is for a neutral process. This process hasn't been neutral. This should have been transferred to another circuit court to look at, which is what has happened with every other case. For some reason, the Federal Circuit decided that it wanted to do this investigation itself of its own judge. And we feel that that's a big part of the problem and a big part of the reason why this process hasn't been neutral and appropriate.
All right, Mark Chenoweth, the President and General Counsel at the New Civil Liberties Alliance. Thank you for your time this morning. We appreciate it.
Thank you.